Hi, a very good afternoon to everyone. We are very happy to have William with us this afternoon. Maybe I can let William introduce yourself. Yeah.
Hello, good afternoon everyone. My name is William da Silva. I'm a lawyer and the CEO of Adams & Marshall, Singapore.
Wow, okay. So William, what do you do actually? Maybe can you share with us a little bit more the area of work that you are doing? I mean in the legal field.
Yeah, sure. Basically, I've been a lawyer for more than 30 years. We covered quite a lot of ground in various areas of law over those years. Currently, Adams & Marshall focuses on corporate commercial work. Right? So we focus on business owners, we focus on the companies, we focus on the internal structure of companies, your corporate governance, your internal agreements, like a partnership agreement, shareholders agreement. Then we deal with the business law side, which is when you have dealings with third parties, external parties, the company and its suppliers, its distributors, its customers, and so on. Right? And then lastly, we also deal with the dispute resolution. So when relationships break down, either internally in the company, between the directors and shareholders themselves or partners, or between the company and the third parties, the external parties. Okay? And the last part is, and again this focuses all on business owners, right? Once you've made the money, you need to secure it, to secure your business legacy. So we also focus on that part as well, where we handle things like your family office, private trust companies, and various other trust arrangements.
Wow, it sounds like a very extensive scope of area that you are doing in the area of corporate services, right?
It's like what the Chinese would call a one dragon solution.
一条龙.
Yes.
一站式 one-stop service. Correct?
But focusing on the business owner and business. So that's what we do. So we don't really do divorces, we don't do personal injury claims and all the stuff.
Sure. So more on the corporate level, on the business level. Alright. Just now you mentioned something that's very interesting. That is, you said something like about disputes. Alright, about handling of disputes, litigation, areas like that. So, you know, a lot of times when we are in our day-to-day kind of environment, where we are doing shopping, even having maybe some more informal kind of agreement sometimes between individuals, be it in terms of business or even sometimes with written agreement. Okay, and sometimes I think some of such agreements or even contracts, there could be non-fulfillment, and there could be already how do you say, considerations even, yet maybe services not delivered, isn't it, right? Then a lot of times they will be thinking, hey, how, you know, because sometimes quite a significant sum of money may already be involved, and you can't just take it lying down like this. So under such circumstances, would you recommend suing? You know, it's like sometimes I don't even have people sharing with me sometimes in terms of contractually, even with their employer. Sometimes it's like, hey, non-delivery, changing of terms suddenly, they become very upset. Then they say that, hey, I want to sue my employer, or even sue another business for non-fulfillment of contract, not even on the terms, and even non-delivery. Yeah, so under such circumstances, do you think it's a good idea to sue? Because to me, suing seems like it's going to it sounds very costly to me, in my opinion, right? So I was thinking that, especially with the stress of going to court, you know, waiting for the outcome, and you don't know how it's going to be. And another thing is, I think legal costs can run up quite significantly. Sometimes at the end of it, we may not be even sure whether, you know, was it even a good idea for me to even start pursuing this matter, right? So since we are in the area talking about disputes this afternoon, maybe William, you can share with us a little bit more. Under a circumstance like what we just mentioned just now, is it a good idea for us to, you know, as laymen, to even pursue it further, or even to sue, you know, and what kind of considerations should we think about, you know, when deciding what course of action that's best suited for us?
Yeah, okay, Pek Cheng, that's a very good question. So I will give you a very good lawyer's answer.
Okay.
It depends.
Oh.
I'm sorry, okay? Because it all depends on the context. There are a few key factors that you must consider, right? First of all, when you think about disputes, if you're talking about suing or going to court, right? Think of it as going to war. Okay, right? And it's very easy to start a war, very difficult to get out of it or to stop it.
Yes.
Okay?
Yes.
So before you start, for me, what we would always tell our clients or people who come to see us about this kind of issue, you need to start at the end.
Okay, start at the end.
Start at the end. Okay, that means to say, you put yourself in the shoes that you start the case, assuming you win or you achieve everything you want to obtain, all your goals. What will your position be at the end? Where will you be? Okay, then from there we start to work backwards to see how can you get there. What is the most appropriate or the most efficient way of getting there? And in fact, I am coming up with an ebook on this. I got also on this thing. It's called 3 Secrets to make sure you win every court case you or your business are involved in.
Wow, sounds interesting.
Yeah.
I think I may need that book.
Yes, we can all do with that.
Right.
Okay, so just to summarize, okay?
Yeah.
The first thing is, of course, is what's the value of the claim?
Sure.
Right? Because suing someone, if you actually talk about going to court, is never cheap. It always involves money, right? So you got to look and see, is it worth your while to do, right? In other words, your money, how much money are you prepared to spend?
Yes.
The other person's money, how much can they pay to fight the case? And thirdly, do they have the money to compensate you and settle with you? Right? This is called follow the money. This is the first rule, one rule. Follow the money.
Okay.
Right? My money, his money, and the money I want to take.
Okay, okay.
So you sue the person or the company who can pay you.
Okay.
Right? You sue the person who can pay you. Okay? So what is important then? If you're going to go to court, whether it's a big case, millions of dollars at stake, or a small case in the small claims tribunal, right, because of the massage parlor incident,
yes,
it starts with the letter E, and the word is evidence. Proof. Right. You must have evidence. Okay. To
substantiate what you're trying to say.
Right? Because when you go to court, if you are the one making the claim, you are the one starting the law case, you have to prove your case in court. You have to convince the judge, right?
Yes.
Okay. And what they call the balance of degree of truth is what they call a balance of probability. That means it's more probable than not. So if you talk about, let's say say for example, the accident that you had, where the guy came from the back, right? Yes. Because you probably didn't have a rear view camera.
Exactly, that's the thing. We have the front one, so since then we have a rear. So that we can have all angles covered.
Why? Because then you have the
evidence, the E word.
Yeah, the E word, right? The last time you had no E, you didn't have the big E, so therefore you have to settle for it, right?
Sure.
So those are really the key things, right? Follow the money and the evidence.
Alright.
And then the last thing, of course, is always, because under our Singapore law, which follows British law, the basic rule is, now you ask, what kind of evidence? What kind of evidence can I bring to the court? Can I bring a tape recording? Can I bring a video recording? And the answer to that is, the law is very simple. The basic rule is, anything that is relevant is admissible in court. It's evidence.
Right. But admissible versus can be brought in as evidence. Is there a difference between the two?
There are some legal rules behind it. There are certain qualifications, but this is the basic rule. So if it is relevant, it is admissible. In general, there are certain exceptions to it, but it's complicated. You got to go through years of law school to go study it, and even lawyers in practice, we are always fighting over this in court. In front of a judge, say this is admissible, this is not admissible. So for purposes of this talk, anything which is relevant is admissible. That's the basic.
Anything that's relevant is admissible.
That's the starting point.
I see. Oh, okay. I thought the part about following the money, that part is really very interesting, like quite an eye-opener to me.
It's actually very basic. Because our system of law, which follows the British system, even after you win the court case, it's up to you to take further measures to get the money back.
Oh, okay.
Right?
I see.
So you cannot assume just because you win and you have this nice printed letter from the court which says judgment and Mr. XYZ or company XYZ owes you or has to pay you $100,000. It doesn't mean that they will pay you.
Oh, that's interesting.
You may have to force them to pay you.
So basically, it's more from the court. It's more of an order to get something done.
Yeah.
But we also must have a relative confidence that this can be executed and followed through.
Yeah, and get the money back actually.
I see.
Yeah.
Okay. So that brings also that's the point on the follow the money, because if they don't have the resources, there's no point in wasting our time to even get to do this.
If the company has already ceased business, they're not operating, they have one registered office, right? Or with individual, the guy is already bankrupt or near bankrupt. When your lawyer checks and they will tell you, oh, Miss Sim, there's a long list of creditors, 20 fellas suing him. Do you want to be number 21? Okay, so it's very
a painful battle.
Don't bother.
Oh, okay.
I mean, it's a question of like they follow the money. Now, sometimes people are willing to throw the money in because why they want to teach the person a lesson. So that is different. That's another category.
That one is like more of getting yourself hurt.
Yes,
just to make a point.
Yes,
correct. I've heard of cases where people just want to make a point. Yeah, that is also provided you can handle the outcomes, isn't it? Because if you lose, then you may have to, from my understanding, I may even have to pay the other side.
You will.
I will have to. Oh, okay.
And that means whoever loses, in Singapore Hokkien, because you're going to pay two sets of costs. You pay your own lawyer, you pay the other side's lawyer.
Especially if it's a long drawn one, right?
Yes.
Yeah. So really have to be very careful,
Think first.
Think properly,
and
don't let your emotions. Exactly. This is going to be my second question. Actually, any other alternatives other than suing? What other kinds of work do you do related to this, where it doesn't quite involve going straight to the court?
Okay. Actually, there are a number of alternatives. Right. Nowadays, they call it ADR or Alternative Dispute Resolution. In fact, in Singapore right now, under the rules of court, because the rules of court were changed quite recently, right? The rules now actually encourage parties to try and settle without having to go to court.
Is that mediation? Is it considered?
So mediation, you can offer mediation. That means, for example, you will still go and see a lawyer, right? For instance, the lawyer will send off the first demand letter to say that you caused this damage to my client, right? We want a claim from you, how many 100,000, pay within 7 days, whatever. But as an alternative, we are prepared to go for mediation, or maybe we are prepared to appoint a independent expert to assess the damage, by some reputable third party, right? Both parties agree, and so these are some of the options you can offer people at the start of the case, to try and avoid the cost. But of course, mediation, any other kind of settlement, negotiation, and so on, always depends on both parties being sincere.
That means agreeable to come to an outcome together. Am I right to say that? It's just like a married couple who want to make things work. And
of course, there will be cases where very often one party will say, I don't want to pay you. Right? I'm not responsible. I don't agree even to pay half. My lawyer says I can fight the case. So there could be many reasons. Or it could be, for example, in the case you are suing a company, if the claim is a large one, maybe for some reason the defendant company needs to buy time. They may want to settle later. They cannot settle now for various reasons. It could be no money. It could be maybe there's some major deal they're working on, and having the lawsuit will jeopardize it, right? So many reasons, right? So it is actually very common that lawsuits start in court, and then halfway through it gets settled.
Partway. I see.
Also, it also happens that sometimes at the beginning, because everyone is a human, right? Even companies are run by human beings, right? Your managing directors, your CEOs, or whatever. And like I said, when people are angry, you're feeling very unjustly treated. right? Then it's very easy to say, I want to sue this fellow. Let's start, get the lawyers in there. We'll pay them, blah, 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 blah. All right? And the other side also, they say, no, this fellow suing me. I don't agree. This fellow, blah, 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 blah. We will fight him. We will teach him a lesson. And after 6 months, 9 months, all right, they're like so tired. Can we settle? Okay? That's when the reality sets in, because I don't know if you've ever been in a court case, and your audience also, right? Those of you who have, you can share with your friends or share with us, what was it like, right? Because I would understand that it's very tiring for the client, all right? It takes a lot of time. You spend a lot of time in your lawyer's office, you get to see them very often and get to know them very well, okay? Yeah. It's very personal, and then plus the cost, right? Because every time you go and see a lawyer, you're like, hello, guys,
that part is honestly, that part is scary to me, because, you know, even including taking calls, things like that, all these are time costs, right? So the lawyer must be fair to them, they're also earning a living, right?
Yes, don't forget, be fair to them. Be fair to your lawyer.
Yeah, be fair to our lawyers. Yeah, I understand that. Also the part about collecting of evidence can be very stressful also.
Yes, because you remember I was saying that the general rule is everything that is relevant is admissible.
Yes.
Okay? And often that may mean the lawyers and you yourself, the claimant, you have to help the lawyers, right? The lawyer can't do everything on his own.
Exactly.
You got to assemble all this evidence. Okay? It could be from your emails, letters, WhatsApp, SMS, Facebook posts, right? It could be oral or verbal evidence from your friends or your business partners who were there. Your own statement also counts as evidence, you know. If there's nobody else, only you and the other guy, what you say, what you write is your evidence. If you made a police complaint, right, or a statement or an insurance claim, that also can be evidence.
Yes, that's why it seems like there's also a lot of work that has to be done there.
Yes.
Yeah, just to prove your point.
Yes.
Yeah.
And this comes to the third point. Okay? When we talk about evidence and you go to court, remember I said you have to assemble the whole collage of evidence, right? All the facts. It is like putting together a whole jigsaw. Little bits you put, you try and fit everything together, and hopefully you put it all nicely, then the judge will look at the whole jigsaw and say, yes, I agree with the picture. But often in real life, pieces are missing. Then you're asking the judge to try and accept the whole picture with some holes, or a lot of holes, or many holes. Okay? Or maybe all holes, right? It all depends, okay, on how good. So, one of the main things is the quality of evidence.
Yes.
Okay? And the best evidence is always something which is written. Right?
Yes, in black and white.
Black and white, right? So it might be by way of text messages, by email, right? Because those are the things where you can substantiate. It often has a date and time, right? Which shows it's contemporaneous. Okay? Because often people's memory over the years changes. So when the case comes up, the guy goes to court and says, yes, we agree on this, this is what was said. Then you show them the emails from 3 years ago, this is not what you said, sir. You said something very different. And I think I forgot.
Yeah, sometimes we really forgot. Yes.
So then fighting and still get what you want, get to achieve your goal. The best way is to have a contract.
Yeah, okay. A written contract.
Yes, at the time, at the beginning, before you all start fighting. So, for example, if you set up a new company, a new business, it's probably a good idea to have a shareholders agreement or a partnership agreement. Right? So you decide among yourselves who's in charge of what aspects of the company, how will you make important decisions, if somebody wants to leave, okay, is there a mechanism to decide how to take over his share, how do you evaluate, right? So that you don't have to go to court and fight, because everything has been pre-agreed. Okay? Rather than to go 4 years later, then the guy will say, oh, you know, remember that day we had coffee and you said this, and then you said, no, I didn't say that, you are misquoting me. Then it goes on and on, right? You end up in court.
Yeah, yes, fully agree. Actually, that is also one good way of living very good evidence, and with everybody understanding, signing off,
absolutely.
Right? Yeah.
If you have a signed document, an actual written agreement, that is probably about the strongest evidence you can get.
Very intentional.
Yes, and it's also the document itself becomes legally binding. It's a contract, right? You can actually sue the person based on the contract. It's not just evidence, there's also an actual agreement between you. So it adds extra strength to it.
Good. Yeah, I find this to be very enlightening. We're very happy to have William with us this afternoon. I think you probably will have learned as much as me in this area to sue or not to sue. Alright? Remember, if you can't remember all the points that were shared just now, just replay our video again and again. Right? Get some insights on it. Yeah? If you have related issues that you hope that someone can probably give you some advice on, in our following link, you can scan our QR code at the end as well. You can book for appointment with William for a consultation. Alright, yeah. So with this, I wish you a very good day and rest of the day ahead. Yeah, goodbye.
Bye.